Here we go. Stuff. All right. Well, welcome everyone. I'll leave that here because if you ask a question, you need to use this so that people on the live stream can hear. So we've got a camera up there; they can see me up here, and hopefully they can also hear me. Look, thank you for devoting Friday afternoon on hearing from me. Now, who's been to one of these before? One of our firm's business essential seminars? Afternoon. Great. Look, for those who haven't, we hold one every couple of months here at our office on a Friday afternoon, and each one's based on one of the areas of the law that we practice here. These seminars, I like to treat them more like conversational workshops rather than a formal presentation. So look, please ask questions as we go. That'll be more difficult for the live stream, as I know, but I find the more that you interact, the more you learn, all the investment of your time will be worthwhile. As I said, this event is being live streamed and recorded and may be used for future educational promotional purposes. For the remote viewers, I will try to answer any questions left in the Q&A at the end of each section. So Aidan, if you can remind me to do that, I'd be grateful. But as I said, if anyone in the audience has a question, please remind me to give you the microphone so that the live streams can hear it. Otherwise, I'll have to repeat it. I'm doing that. A bit of background about the firm for those who haven't heard. Apologies to those who have. Danny Clifford and Ben Gouldson started the business in 2006, and since then we've grown to having 3 offices: Toowoomba, Brisbane, Sunshine Coast. We employ around 40 staff, including around 20 lawyers, across the 7 areas of law that we practice, which you can find on our website. I won't bore you with all those, but cglaw.com.au, or just search for the firm name. A bit about me: I'm one of the directors of the firm. I head up our litigation, dispute resolution and construction team. I've been practicing in these areas about 19 years now, some of which was before I was a lawyer, in case you wondering how that computes. All right, let's get into the subject matter. It wouldn't be a good lawyer's presentation without a half-decent disclaimer. The part I like more about this is that here, not only does a lawyer give a disclaimer, but then we promote ourselves whilst doing it. Isn't that nice? Hey? I didn't write it, but I sort of quite enjoyed that. Welcome. Plenty of seats still. All right. Now, admittedly, today's topic is a little morbid, but given the response we've had to the invitation, we sold out the in-person within a few days, I think, or under a week, and there's another 30 registered for live stream. It seems like it's relevant and topical. It's a little morbid, but as any wills and estates lawyer will tell you, it's an uncomfortable but necessary conversation. That is what's to happen to your assets after you pass away. Now, estate disputes are on the rise, and that's likely because one of Australia's largest and wealthiest generations, the baby boomers, are unfortunately, inevitably reaching the end of their lifespans. In case you were wondering, for Australian women, I looked this up this morning, the average life expectancy is 85. And for men, you want to guess? 82 is pretty close to 81. So, yeah, 4 years difference at the moment. Probably not surprising. Now, can I ask, is anyone acting as an executive of a deceased estate right now? Yeah. And what about, is anyone named? Do they know if they're named as an executive? Quite a few. What about a beneficiary? Does anyone know that they're named as a beneficiary in the will? About half the room? Yep. Maybe you're named, but you don't know it. That'd be a nice surprise, potentially. And what about those who advise on succession planning? You as well. Great. All right. Well, what leads to an estate dispute? I've got 10 examples there. Estate disputes, or otherwise known as conflicts over a deceased person's will or estate, often arise from a mix of emotional, legal, and financial issues. And we find the most common causes of those listed on screen in the PowerPoint. Now, someone dies without a valid will. That's called dying intestate. Their estate's distributed according to the Queensland Succession Act. There was no ifs, buts, or maybes. That's how it's done. Just sets it out. And it's often not in line with what the deceased wanted. They might have expressed along the way what their intentions were with their deceased estate, but they didn't make a will, then Succession Act applies. And look, broadly, it's spouse, then children, parents, and then it goes into grandchildren, brothers and sisters, nieces and nephews. There's a set order. The point is that there's no choice. The Act just applies if you don't have a will or a valid will. And as you can imagine, that leads to arguments among family members or partners or who should inherit what. Unclear or poorly drafted wills. So vague language, contradictions within the same document, outdated clauses, just creates confusion and unfortunately multiple interpretations of the document, which in the case of a will is pretty important to avoid. Perhaps, and this is pretty rare, but the will might have been seemingly tampered with or forged. That doesn't happen very often, but that can, as you can imagine, lead to an estate dispute. You just don't want to. You want to avoid the situation of somebody asking, "Well, what did the will really?" And if you have asking that question, well, that's category of dispute. Unequal or unexpected distributions is a big one in my experience. One child, for example, receives significantly more than the others. Someone's disinherited entirely. That sparks resentment and quite often, increasingly, a legal challenge. Stepchildren, ex-spouses, new partners may further complicate matters as a matter of practicality. Claims of undue influence. So that's where, someone, whether it's a child or otherwise, got in the ear of the deceased, but went too far to the point of it becoming manipulative. That's what I mean by undue influence. That's a legal principle. Signs of that are if the will was changed later in life or just before death to either increase the person who's in their ear, their inheritance or their share, or just include them at all. They might have not been in there at all, and suddenly now they've got a piece of the pie. And it's not just enough for the person to do that. The deceased has to have been vulnerable. So due to illness, whether that's physical or mental, or a dependency. They just might have really relied heavily on that person for their day-to-day living or affairs. Might have been the power of attorney, for example, over medical or financial matters. Capacity is another big one. So if there's any doubt the deceased had the required mental capacity when making or changing their will, that can be if there's hints of dementia or Alzheimer's, just unsound mind due to frailty or old age can be enough to make someone not have enough capacity to make a will. You actually have a fair bit. It's not enough to say, oh, if they're okay, sort of know what's going on. Make a will is a pretty important decision, so you need to have a fair amount of capacity. Executor misconduct or disputes, that's probably in my experience a bit rarer than the others. But disputes can arise where the person managing the estate is thought to have acted dishonestly or delayed unnecessarily or seen as biased towards some beneficiaries over others. And if that happens, then the beneficiaries can apply to the court to remove or replace the executor. Blended families, I sort of touched on that earlier, but disagreements often arise in our experience with families with stepchildren, second spouses or estranged relatives over what's fair as between past and current spouses or stepchildren and children. Family disputes, this is another one we're seeing more of recently, in my experience. So when it's a family property or a family business, especially rural property, and if one beneficiary has been more involved in the family business than others, they might get less than what they think they're entitled to, or the others don't get anything. They think, well, I should have got something, or that person got too much. That's a big one, my view. And in fact, further to that, I've got it might be a personal theory, but when it comes to family, I think jealousy plays a big role in these types of disputes. And look, broadly what I mean by that is where there is a perceived favourite child, or one child feels like the black sheep, then nothing like a will or a deceased estate to bring those feelings to the fore. And the envious child can seek to right past wrongs by perceived wrongs by the deceased parent by challenging the will or the estate. So it's not actually about getting more from the estate. It's really just a justice or an even up exercise. Look, that gets found out if it goes to final hearing, but again, it's what can lead to an estate dispute. Another big one, unmet promises or verbal agreements. Just had one recently where the son was getting the family property, and the daughter didn't want the whole family property. Got some house in town, some other land, largely not equal in value, but didn't miss out entirely, that's for sure. But there was always, according to the daughter, Dad would look after me. And the way that the will ended up, in her view, wasn't being looked after. So, of course, the other side of the fence was, well, you had a husband and a family, so you were looked after, whereas the son was single. So that's a common scenario we come across. Mum said I get the house, Dad said I get the property. If the promises weren't in writing, then of course disputes can arise over whether those assurances verbally should be honoured through a claim on the estate. And then finally, financial dependence. So it works both ways. So individuals who relied on the deceased financially, which can be a dependent adult, not just kids, that may feel entitled to more than what was left to them and contest the will. Equally, individuals who feel like they made heavy sacrifices to care for the deceased while they were alive or look after their assets or affairs when the deceased couldn't do that themselves anymore. They may naturally also feel more entitled than others if they didn't get a bigger share. Then that leads to an estate dispute. But look, can anyone think of any other reasons or scenarios that would spark an estate dispute? Does anyone come across any other scenarios that might not fall into one of those categories? Oh, sorry. Told you I'd pick it. Oh. Yeah. No, they heard me. So sorry, you were saying, let me try to paraphrase. It's a situation that might fall into financial dependence, where a beneficiary, someone that, is a beneficiary, but they got less than the others. So there's an unequal entitlement in the will.
Yeah, so there's an unequal entitlement, and that beneficiary that got the lesser is actually in probably a worse financial position than everyone else, and probably needs more as well. I'm envisaging, I guess I'm looking into the future. This is something I think I'm going to have to deal with. So I guess it's a bit more personal, but is that, I assume that I don't know if that's grounds for any legal dispute there or not, but I can see it's going to happen.
Yeah.
Yeah.
It's certainly a motivator, and probably doesn't fall into one of those categories. It may not be a feeling of, inequality. It just may be, well, I need more. Right now I'm struggling, and there's a pot of money, if you like, that I might be able to access some of, or more of than what I've been left. Yeah. And in fact, probably stealing my thunder a little bit, we'll get to why the applicant's needs are really relevant in an estate litigation. So, yes.
I'm thinking, I've been in one case where there was the reimbursement without pocket expenses.
So a estate dispute over reimbursement without.
Yeah, so the estate hadn't been settled. There was no probate or anything at that time, but there were a number of out-of-pocket expenses, including funeral expenses and the like, as well as time spent in preparing appropriate documents. And it was a claim which became a dispute.
And so that was by someone other than the executor, I'm guessing. Was it by a beneficiary or? Yeah.
In which to directly pay these items, and they had paid them themselves. They made the offer to pay it.
And they actually incurred the.
Yes.
expense?
Yes.
Yeah. And are they a beneficiary?
No, they weren't.
Just a third party who was obviously somewhat known to the
Yeah, someone
the deceased. Yeah, a friend.
It was a friend.
Yeah. Well, I mean, generally, the estate would eventually, if it's able, after paying its debts, reimburse those expenses if they were properly incurred on behalf of the estate. So a funeral, that's an obvious one. Yes, if someone pays for that, and there's money in the estate, then that would be reimbursed. But other expenses, then the executive might say, well, is that really for the benefit of the estate? And they challenge the reimbursement. You've got to prove that you incurred the expense, which have receipts.
Yeah, I believe it was things like removal of vans to
Okay, well, that's probably.
remove furniture from the house and that stuff like that.
So what was the dispute, if I can ask?
Well, the executive refused to pay it.
Right, on the grounds.
I don't know enough about that.
Well, look, certainly it's an example of an estate dispute that's not in that category. So yeah, from that perspective, you're right. But generally, in my experience, if it's genuinely an estate expense and the estate can pay it, and it's proven to have been incurred, then it will be paid. Eventually, it might not be paid soon, quickly, because the executive might sort of want to pay other things or get probate, access cash for a bank account. Yeah. Okay. Anyone else? Yeah. Okay.
Just wondering, Harrison, if you could cover whether people are having trouble choosing executors, like with the public trustee being on the nose, and cases where like mental health in children, and who do I pick if I can't pick any of my kids to do it?
Yep. I will, but I've got that coming later. So yes, definitely that is part of it, and it is an important consideration because it actually picking your executor can avoid. One way you can reduce the risk of a state dispute, picking a good executor. This is sort of some closing remarks on this point. In my experience, it comes down to feelings of deserving. People often talk about, we should respect what the deceased wanted. That's often what comes out of their mouths. People who benefit, who are beneficiaries in the will, Whereas those left out or don't think they've got enough, well, I did this, so I deserve more. Or, you know, one of the other beneficiaries did nothing for the deceased, so they should get less. You know, that's some really common phrasing that we hear around state disputes. And I think people are feeling this, and probably rightly so, feel like they are in a really good position to determine who deserves what from an estate. Whereas, and because maybe the deceased is no longer with us and can't explain why they did their will the way that they did. Anyway, I just thought I'd add that remark around what people feel like they deserve and what others feel like they deserve. When it comes to estates, so more relevant. Yeah. Yeah, I mean,
Where did
as in, like after the person passes away, to say, well, yeah, look, you made your will, but we don't agree with it. Well, the Succession Act came in 1981. That might be the answer. But to be honest, I don't know when these particular sections of it started, whether they were from the beginning in 1981 or came in since. If I was to take a stab, I'd say that these ones have been there for a while because the case law around this is pretty old. I think what I'm going to say soon will help, will at least partly answer that question. But good question. Of course, the flip side of that, or the following question is, well, why bother having a will? That's effectively what you're saying. Well, wills are very important, and you don't need lawyers and suits to make one, although, as we'll come to later, it's a really good idea. Yes. Oh, sorry, I've missed both questions. Sorry.
what percentage of wills are being disputed now, and how is that rising, and how by how much?
Yeah. Oh, look, I don't know the exact stats to answer the question, but they are on the rise. I mean, anecdotally, in the last 12 months, we've probably seen, we might get less than 5 generally a year. I think we've had half a dozen under the last 12 months of state dispute. So certainly, I think it's increased. And that may be because there's more to fight over. I expect more people, a large percentage of people are passing away, but equally the people that are passing away now, because of where the wealth in Australia is concentrated, there's something worth fighting over. And yeah, that's where the wealth in the family is or was. It hadn't been distributed pre-death. Sorry, I should repeat your question, Nick. Correct me if I get it wrong on this. You effectively said, why bother having a will? And when did it become a thing to contest will or ask for more from estates? That was, yeah, or largely ignore what the deceased did with their will. That's for the live stream. All right. It's going on the screen on the laptop, Aidan, but it's not going on the big screen. We can't win that. The sound. And I also have to use the arrow or the space bar. done this one. No, you're right. Can the live streams see that first? Oh. I was going to say, hit the transformer again at least. Try it now. Yeah, it's not done. Hey. Yeah, I think it's working. Yep. If I just go down arrow. Down arrow. Right. Wasn't much to see anyway. How can wills be challenged? Two most common ways a person can contest a will is they're unfairly left out, or they believe they're unfairly left out, or they believe they receive inadequate provision from a will. Then you make a family provision application, or otherwise known as a family provision claim. And sometimes they're also known as a further provision application or claim if you're actually in the will but you want more. So if you didn't get anything, family provision application or claim. And the second one is if you seek to invalidate the will, undue influence, lack of capacity, or not meeting legal formalities or compliance to be a valid will. I think the truth. Hey, okay, didn't it work? All right. Now I think hopefully this section will answer some of the questions. Making or defending claims against the deceased estate. So look, given we've got about 45 minutes today, I'm not going to cover the seeking to invalidate wills today. But if you want some information about that, please email or call me. Let me know. I can provide some. But today, because there's a bit in this, we're going to focus on the first of those ways you can contest a will, and that is family provision applications. As I said, which we've seen a spike of. Family provision applications in Queensland governed by Part 4 of the Succession Act. Eligible applicants, the eligibility, right? This is the first test, if you like. First hurdle you've got to get over. If you're not one of these, you can't bring one of these applications. The deceased spouse, children of the deceased, and dependents of the deceased. If they believe adequate provision has not been made for their maintenance and support. That comes to that financial need piece. So spouses include de facto partners, and a dependent is someone who is wholly or substantially maintained or supported by the deceased at the time of death. That can include parents of the deceased or minors. So someone under the age of 18 can bring a claim. They just need a litigation go. In terms of time limits, the prospective applicant must first give written notice of their intention to make a family provision application to the executor within 6 months of the deceased passing away. So that's just a letter to the executor that says, I intend to make a family provision application against the estate. However, failure to do that does not prevent a claim from being brought. Instead, it provides the executor with protection against any distribution properly made after the 6 month period before the claims commenced. So that notice, what it effectively does is just puts a hold on distribution to beneficiaries. So executors shouldn't do any distribution in the first 6 months. In case that notice comes on the last day of the 6 months. If one comes, you still don't do any distribution. You wait until a claim is brought. And if a claim is brought, you still don't do any distribution. But if you don't get that notice, you can start to distribute after 6 months. And then if a claim's brought, well, that's too bad to the applicant if there's less in the estate because it's already been distributed. I'm following kind of little sort of timeline. The application itself must be filed within the court within 9 months of the deceased death, although the court can extend that period in certain circumstances. So it's a strict time limit. Sorry, it's a hard time limit, but it's not strict. Legally, if the time limit is strict, there's no extending. So what I'm trying to say, I guess, is that it's a hard time limit to extend, but it is possible in certain limited circumstances. One being the discovery of new evidence after the 9-month period. If that wasn't to light to the prospective applicant, that would be a reason you would ask for an extension of that 9-month period. If they couldn't make the application for reasons beyond their control, they were unwell, a close family member was unwell. I'm just thinking of possible examples, but you are far better off making your application within the 9 months. Now, let's say the notice was given, that the application was filed all in time, and you haven't sorted out the claim, and it's going to go to trial court hearing. Well, what does the court? How does the court decide these matters? Well, when determining what the court's got to determine is whether adequate provision has been made for the applicant's maintenance and support. That was that terminology I was using before. Court exercises discretion and considers factors such as the applicant's circumstances, particularly their financial position, the applicant's relationship. So, sorry, I'll jump back a second. What I mean by their financial position is whether they have need. That's what the court's looking for. So if you're, well off, you're meeting your expenses in life, you don't really need any more to look after the people you look after the assets you've got, then that's probably going to count against you in an application for further provision. Whereas, if your circumstances mean that your ability to earn an income or an increased income over the course of your life is limited, then that's an example of why you might be entitled. It's only one of the factors. Next one is the applicant's relationship with the deceased before they passed away and over their lifetime, especially if they were dependent on the deceased. So if you were in any way dependent on the deceased, that's going to help your claim. The size and nature of the estate is relevant too. I had one last year where there were 3 children, and none of them, well, they only got a little bit really of the estate. The vast majority of it was left to brothers and sisters. The deceased hadn't really had a relationship with his kids. They were mostly estranged and had been for maybe more than a decade or longer in some cases. Anyway, they all brought an application for the provision. But this was a relatively large estate. There was, if you look at the people who are eligible, plenty to go around. It's probably the way that everyone's looking at it. Saying that, none of the applicants really, maybe one of them, had any real need. And we were for the estate. So we were acting for the brothers and sisters who were the executors. And I think, the matter didn't go to the final hearing, but I think if it had, I think those applications would have failed. Maybe that one of the kids who had a husband and kids, younger kids, so a whole lot more expenses. They had their own business as well, which had expenses. So she might have got something more than what she was given. But I think the other 2, they were doing very well by all standards. So I think they would have struggled. And none of them were dependent on the deceased. And they'd all been estranged. So there was a fair bit counting against them. But one thing that would have been for them, particularly the third child, was the size and nature of the estate. There was plenty of cash, property. So that would have been a factor the court would take into consideration to perhaps give that third one something. And then the conduct of the applicant's important as well. Is probably the 4th relevant legal principle. So the courts may refuse applications for family provision if the applicant's conduct disentitles them, or if the circumstances make refusal reasonable. So for example, estrangement from the deceased, misconduct as to the deceased or the deceased assets, and doesn't have to be criminal conduct, although criminal conduct is probably going to be disentitling conduct. It doesn't have to go that far. Just, yes. Oh, I'm remembering.
Thanks, Harrison. Could you just expand on what the court would consider to be misconduct? Would that be like malicious postings on Facebook type things or that, or does it
About
have
the
to be a
deceased?
physical act against the estate?
No, I wouldn't say it's limited in that way. But if, yes, there had been continuous, maybe not to the level of defamation, but let's say negative public outbursts, then yes, I think that would be taken into account. Yeah, I wouldn't say it's necessarily disentitling conduct. It's only one factor of the four. But yes, that's going to count against, in my view.
Sorry, while I've got the microphone,
yeah.
could I just ask one clarification? You said there was a 6-month limitation and a 9-month limitation. What's the difference between the two?
Good question. So I probably went too fast then. 6 months is when you need to give the letter or the notice to the executor that you intend to make a claim. You don't have to make the claim within 6 months. That's when the 9-month time limit comes in. That's when it's relevant. So date of death to 6 months. In that period, that's when you've got to give a notice, a written notice to the executor that you intend to make a claim. And within the next 3 month period, you're going to make your application to the court. All right. Now, look, the overarching aim of this law is to balance, I think this will go partly to your point, Nick, is to balance the deceased's testamentary freedom. So effectively do what they like with their assets in their will, balancing that against their moral duty to provide for those reliant on them. So the law says that, yes, you can do what you like with your will, but you got to look after those that are dependent on them. So yeah, I've got here, in other words, whilst the deceased wishes are respected, they may be overridden to prevent hardship to eligible dependents. So it's this balancing act. Yeah.
So hardship, and I guess the standard of living of the person making the claim, is that factoring? Like, I mean, if they've got means to provide the child with an education, albeit maybe a, public education, but they really like them to go to the private school but don't have the means, where does it sit in relation
That's a really
to
good
that?
question. I found that when I first started doing this, I talked to the barristers that we would engage to help with these matters about those very issues. And I guess the best way I can answer it is it's to what that family is accustomed is actually quite relevant. So if the brothers and sisters of the deceased enjoyed private education, then perhaps their children should too. But again, it comes back to that one of those factors I talked about before, the size and nature of the estate. But can the estate bear that? So the applicant, in a few of them I've seen, say, okay, I've got kids, of the grandkids often of the deceased. I want them to go to private school. And the court could say, okay, well, can the estate afford it effectively? If it can, and that applicant is deserving, is my word, then that could well be afforded, yes. There's no standard or average standard of living. Yeah, that's what you're asking. Yeah, no, there's the particular factors of that estate and that family are taken. I think we've probably already had some questions around or thoughts or comments on the fairness of our laws in this regard. But if there are any questions or comments in that regard or scenarios, hypothetical or otherwise, people either have. Yep.
I've seen a number of cases where the will has made a particular statement, and then the person has added an additional letter as an explanation to say, well, look, Johnny he's probably going to come back and say he deserves more, but he's been a bit of an arse, so I'm not going to. So you've got that in your side explanation. Yeah, he is an arse, of course, but
Stealing my thunder, Steve, that is coming in the presentation. But yes, I'll suffice to say for now, that's a good idea.
Again, it was just how is someone who's not had any contact with the deceased for 10 years dependent and able to ask for things?
Well, they wouldn't be dependent. Well, if they've been estranged for 10 years, they're not dependent, then they would be, if I was acting for them, they would need to be emphasising their need. So they'd have to be struggling comparatively. That would help their claim, but doesn't mean they're entitled. Just because you're just estranged and you weren't dependent on the deceased, that doesn't count you out necessarily. Make your claim harder, but yeah, not impossible. Loving the discussion, by the way, team.
Doesn't an executor have a bit of a problem if and hasn't been taken into account in the way the will's been written, but if one of the eligible dependents has got a life affecting addiction?
Yes, that is. So hopefully the live stream heard that. Yes, those something like that, an addiction, is what I would describe as, what did I describe the categories at? So the applicant's circumstances. Yes. They often, I mean, maybe they would, but probably in my experience, they wouldn't fess up to that in their affidavit supporting their application. That may well have to come out via the affidavits filed in support of the state.
It was, if the executor can clearly see that if what that particular dependent is going to be given is going to go into his arm, has he got any responsibility? He or she as an executor got any responsibilities or?
Oh, sorry, I see. So you're saying the will leaves X dollars or assets to said beneficiary. Oh, look, that's a good question. I think the answer is that the executor is bound to follow the will. There are applications you can make to the court to amend will afterwards, but they are without all the beneficiaries' consent. They are difficult to get up. So that's almost like the reverse of what we're talking about here. It's not. The beneficiaries are all saying, no, that's all fine. Nobody's making a challenge. The executor's saying, oh, look, I don't think that's right. Yeah, you need to get the court's approval of that. Yeah. What's it about? So
Just on that, Harrison, if they had a charter of wishes where the will makers said that in this case it was a de facto no financial ability, therefore it needs to be in a testamentary trust for her, blah, blah, blah. Is the charter of wishes going to be enough? Like it wasn't actually documented as a testamentary trust. We were just saying in the charter of wishes, you know, why I want somebody else to control this for her. So it's more like a I don't know, an informal trust, if you like,
Mm.
but knowing she had no financial capacity.
Yeah.
Would that stack up, or is a better way of doing it?
Well, certainly the trust, and as we'll come to later, testamentary trust is far better in that situation, what we just describe as a sensitive situation. But, you know, a letter of wishes or a statement of intent, that's better than nothing. Yeah, so, you know, in order of things, you know, have your testamentary trust for sure in that situation. You're not going to have that, then yeah, something in writing that goes with the will that can be relied upon, doesn't have to be attached or annexed to the will, but if it's in the deceased's possessions, it could be led as evidence. Yeah.
You mentioned there, if a beneficiary got nothing or less than what maybe they thought, and I don't know, maybe they're on Centrelink payments, they're struggling, and you said, and they were deserving, that they might have a case. Is there a definition of deserving, or what that?
Oh,
actually
that's what I mean by deserving. It was about their financial need. That was the context I was making it in, not necessarily their personality, for example.
Oh, yeah, right.
Yeah, sorry, that was unclear.
No,
That's a good,
cool.
good clarifying question. No, sorry, by deserving, it's those factors I went through. The legal test of deserving.
Yep.
The court won't necessarily, well, I mean, maybe that's human, right? If the applicant got in the witness box and carried on, let's say, and wasn't of good character, that's not going to be entitled. The judge might take that into account privately.
Yep. And maybe you're going to touch on it later. There's obviously costs associated with contesting a will.
Yes.
You're going to.
Good question.
Talk
No,
about
I'm
that.
not going to cover that. I'm glad you asked because so that if someone, an eligible person, challenges a will via a family provision application, then the estate's legal costs are generally covered on an indemnity basis, 100%. The applicants are not necessarily. There are a couple of different bases on which costs, or three actually, no costs at all. If they lose, they might bear their own costs. If they're partly successful, or even if they're unsuccessful, but it was, you know, not a hopeless claim, the court might say, well, you can have some of your costs out of the estate. Or if you're completely successful and the court decides that the estate shouldn't have actually defended the matter, should just let you have it what you wanted, you might get all of your costs out of the estate on 100% indemnity basis. That's your question.
Yeah, I guess so. That sounds like there's no upfront cost then. It's
Oh, no, the applicant has to pay their own legal fees up front.
upfront. Yeah.
I mean, unless the law firm does it on a no fee basis.
Yeah, right.
Not too much of that in the estates area.
No.
Yeah. So, and it does settle. Sorry, if estate disputes settle, which they often do, like most court proceedings, before they get to a final hearing. Generally, it's on the basis that at least some of the applicant's costs are paid. Generally, all of them, actually, in my experience.
Harrison, say if an enduring power of attorney makes some financial errors, can the siblings then sue that through the estate, or?
Generally, if it's power of attorney, it'd be pre-death. And so, yes, there are applications you can make, just like you can make against executors, against attorneys.
So, Harrison, what happens in the event that the lawyer who drafted the will is at fault? As an example, the intent was a testamentary trust and it was drafted as in trust.
That's just a standard will.
Yeah.
Yeah.
Whereas the executors or the recipients all thought it was testamentary, but the drafting was not.
If their instructions were clearly that it should be a testamentary trust, and thankfully for us, these claims are hard to prove, but they do get up. I've run them myself, not state negligence, but other professional negligence by lawyers. So you've got to prove things, right? So you've got to prove that there were instructions given in a certain way. Then you've got to prove that the lawyer drafted it. This is normally the easy part, not in accordance with the instructions. Then you've got to prove that there was loss as a result of that negligence. Just because they didn't draft it properly, if there was no change in position or no detriment, there'll be no claim. You have to have suffered loss as a result of or caused by the negligence. Does that answer your question? Yeah. All right, guys, that's been great. I was going to go through, and I'm glad that we've had good discussion on that, because I don't know if I really wanted to go through this anyway. I think people, they come to a law firm for an estate dispute. It's the sort of stuff you'd expect us to know. I don't really necessarily need to explain it. I was going to if there was time, but I think we'll get to the few people have been asking about already. So prevention is better than the cure, right? So I wanted to discuss how to minimise the risk of a will being contested. And in my view, personal opinion, it's all about clarity, legal compliance, obviously, and meaningful communication. Pre-death, hopefully. So number one, this is self-serving, I know, I appreciate that. But DIY wills, generic online templates. I mean, maybe, starting to concede that perhaps ChatGPT and others are pretty good, but they all depend on the prompts you give them, right? So the downside of not getting a lawyer to do your will is that you may miss important legal nuances specific to your situation. A lot of those generic ones are great if you've got a very vanilla standard setup, but most people don't. So a good estate lawyer will ensure the will is valid, obviously, tailored to your circumstances, that's important, and your family's, and considers the potential claims against your estate. So that's the sort of questions you'd be asking, okay? Who's out there? Who have you got? What's your relationship? You're going through those factors ahead of time that we've talked about today. And an experienced lawyer will also be able to assess the will maker's capacity. So not just trying to forewarn against claims, but for family provision, but also against capacity challenges and limit the input of others in the will making process, thereby avoiding an undue influence claim, or at least reducing the chances of those challenges or seeking to invalidate the will. So yes, confirmed testamentary capacity. I mean, this is if you don't get a lawyer. So ensure you're of sound mind when making or updating your will. Really good idea to get it, and often we do this if capacity is in question, we're unsure. We'll go to the person's doctor and get a letter and say, do they have capacity, the necessary capacity to make a will? And often the best evidence is from a GP who sees that person regularly, not a specialist capacity assessor, and there are specialists out there who do it, who might see them one-off. I mean, they're great because they'll have a lengthy appointment, ask lots of questions. You'll get a good report. But often a GP who sees them, weekly, fortnightly, they'll have just as good an idea of their capacity. Especially if the person's unwell or elderly, strong evidence, a doctor's letter against a claimed incapacity at the time of making the will. So we'll make sure that letter's given around very close to when the will's made. I think a few people have touched on this, explaining unequal distributions clearly. So if you're not dividing assets equally, especially among children, consider writing a statement of intent or a letter of wishes to accompany the will. It's not legally binding like the will, but it helps explain the reason. So you might say, well, that person's not getting equal amount, that child, because I've already given them X, Y, Z in life. Prior gifts, special needs, that person's getting more than the others because they've got these special needs, the others don't. Or estrangement is another reason. And this is the other one I was going to say. So discuss your decisions with family while you're still alive to reduce shock later. Seems to make common sense, but it doesn't happen very often. Avoid undue influence. So ensure you're aligned with your lawyer when giving instructions. Avoid having beneficiaries present during will discussions or signings. Update your will after major life changes. I know Sheila here is the head of our wills and estates section, is a big advocate of this. You know, revisit your will after marriage, divorce, birth or adoption of children, death of the beneficiary, major asset increases or decreases. So keeping your will current avoids confusion, prevents claims later. Including all eligible dependents. Obviously that, you know, you might not want to do that, but you should, because it actually avoids family division claims. If you exclude someone who can make one of those applications, so remembering spouse, including de factos, children and financial dependents, exclude someone like that, and they feel they weren't adequately provided for, or you feel that they might feel that way, mention them by name in the will and state why, but not necessarily even in the statement of intent or letter of wishes. Do it in the will for these type of people. Explain why you're not leaving them anything or why the amount is reduced. Shows the omission was intentional, provides an explanation why that may be found to be reasonable by a court if there's an application made. And it could be hard to refute by the applicant. In fact, it may dissuade them from making the application at all. This goes to the point around testamentary trusts. So for sensitive situations, so for minors, you're leaving gifts to kids who may not attain the age of 18 or 21 or 25. You can change the age they've got to get to. It doesn't have to be 18. Those that are financially responsible for any reason, you think that they are, or you think the person you're leaving to is at risk of divorce or bankruptcy, that exposes what you leave to them going to somebody else. So you can set up a trust to avoid that happening, even if that divorce or bankruptcy happens. Choosing the right executor, we've talked about. So appointing someone who you trust, I'll go without saying, but that's very important, to act fairly and efficiently, ideally with no major conflict of interest, particularly if you think that there's going to be some form of dispute as between the beneficiaries who are in the will or those that you've left out. And so you can appoint professional executors. The public trustee, yes, I would agree. Or if anybody knows someone related to someone who works there, but right now we've got one where they're being very difficult. Yeah, I would avoid it if you can, appointing the public trustee as your executor. But there are trustee companies out there who will do it professionally. Of course, lawyers can appoint a lawyer to do it for you. Store the will safely. So with the lawyer in safe custody or safe deposit box are examples. Let your executor and perhaps your beneficiaries know where it is. And avoid multiple copies to reduce confusion of which one's the right one. And then document everything. I mean, lawyers are always telling people to do this, but particularly in estates, as I said before, when we were going through those reasons of why there are estate disputes, I reckon one of the most common is mum said I'd get the house, dad said I'd get the property. Where's that? Is it written down anywhere? So if you're the will maker, either put it in there or keep records of your decisions, including gifts and loans along the way. So if you're doing pre-death transfers, cash, property, shares, doesn't matter what it is, keep a record of that, because that's evidence of that might help rebut a claim in the future by a beneficiary who says, well, I didn't get equal amount in the will. Well, hang on, you got all that during the person's life. And keep notes or letters to show reasoning intentions rather than just telling people they'll get. But I think letters is a good idea. Email these days, I suppose. Now, can anyone think of any other? Yeah. Yeah.
On choosing the right executor. So just explain about if you are chosen as an executor of a will, what are the things that you have to be cognizant of? And, you know, how do you be the best executor in that position? And how do you not get yourself into situations where you might get into legal trouble?
Good question. Great question. Well, I think first of all, the person, it's a bit like giving a reference to someone in an employment scenario. I think the person who's making the will should ask that person, do you agree to be my executor? And if someone asks you that, then you've got to remember that if they pass away, it's going to be a fair bit of time. Even if you engage a law firm to administer the estate on your behalf, they're still going to need you to deal with them and give them instructions regularly, provide a lot of material from the deceased. And there'll be decisions that you have to make that are not explicit in the will. So, you know, the will might be fairly ambiguous or vague, but just leave it up to the executor as to who gets what's called the residuary of the estate. And that you know, if you don't in a will specify valuable jewelry or keepsakes, things like that, that might have a lot of sentimental value. Well, it's up to you to decide who gets that. Unless there's only one beneficiary of the residue, and that's different. But often enough, there is more than one. You've got to say, okay, well, who wants this? Who gets that? And if they can't agree, well, you've got to decide. So you're a bit like a judge in some ways. But it's a serious role. I mean, I've done it at least once. And yeah, it's a lot of look. To answer the other part of your question, though, as to how do you avoid falling foul, well, get an experienced estate administration lawyer to help you. I'm saying that as a lawyer. I got people to help me do it. You don't have to do whatever you want. Yeah, often enough it is that firm because they've met with that person, booked the instructions for the will. They've often got the will stored in safe custody. But you don't have to. You can go to someone else who you prefer. Yeah. Oops.
In the event that the lawyer that has drafted the will, done the will, is no longer in business, what happens then? Because is that the only will?
Yes, well, hopefully, if a firm has shut down, then and they had a will in safe custody, it should be returned to the will maker. Or what I've seen most common though is a firm shuts down and it's taken over by another firm. And they would take the safe custody on. No, well, but it can't just it can't stay in safe custody of that firm because that firm's going to close. So it either has to go back to the will makers or it has to go to the new firm taking it on. I mean, I suppose there are rare situations where a firm just closes and there's no one taking it on, but it can't stay there, so it's got to go somewhere. The person doesn't collect it, I suppose it goes to public trustee. Yeah, I don't know in that rare situation where.
I thought there must have been a bank that was going.
No, that's why I'm struggling with it because there's not.
Oh, okay.
There's no central depository of will.
I was going back to the executor. So obviously it takes time for probate to go through and in the meantime, there's obviously costs that are being incurred for the wills. What happens? Is the executor up for those costs until that
Yep.
is so like for funerals for?
Yep.
So they are okay.
Often enough, for funerals, they can access some cash in the bank account if they can prove they're the executor. But by and large, yeah, like, so for example, our fees, if we're administering in state and there hasn't been probate yet, the executor's up for our fees until the cash comes in, if there is any, from the bank accounts from the estate after probate's received. And then we reimburse the executor's person.
So probate's it sounds like from what I'm getting anecdotally from my clients that there's more estates going to probate.
Yes.
Yeah. So that's definitely, there's just that 6 months at the minimum that you're incurring costs. Is that right?
Oh, so probate and family division application timeframes are different. You can get probate as soon as you start, you can apply for it.
Yeah.
It's just,
But still, how long does it take to get probate? I thought this just.
I don't think it's that long. I know most estates. Sorry. No, I mean, my experience, and this is more our estates team, our litigation team, but yeah, it's within a month or two. Generally, they're applying for probate, and I mean, the courts normally pretty good to it, week or two. Yeah. Sorry.
Thank you. What determines probate in an
Right.
estate?
Validity. So determining whether the court grants probate, you're really just looking whether the will's valid. Does it comply with the requirements of the Succession Act to be a valid will in Queensland?
So why would
No, not to get probate. Whether you need probate to access an asset, sometimes for banks, for example, they say, okay, if you've got less than 15,000 to bank, you don't need probate. We'll just give that to you if you give us a copy of the will, prove you're the executor. But those thresholds are come down. To answer your question, or to agree with you, before probate being required to take over assets is becoming more common, more necessary. But to get probate, the court's just looking at whether the will is valid. Thank you. I don't think I've answered your executive question as fully as I possibly can. It's not an easy one because, I mean, most people, if you're just administering the estate per the will, you're doing your job. I mean, it's difficult to get. You gotta do something like bordering on fraud to get removed. Does that make sense? I guess that I think that better answers your question. Yes. Yeah. I think just because there's a family division application that is made as successful doesn't mean you've done the wrong thing as executive. Yeah. I think that goes partly to it as well. I think if you just, doing things honestly and efficiently, as fairly as you can, you're going to abide by your executive duties. I mean, it's much the same as being trustee of a trust. That may not mean too much, but you've got fiduciary obligations, which mean you've got to act in the best interests of the estate, not your own. Tick that box, you'll go a long way towards doing the job as an executive.
Do you recommend that people
Sorry, oops.
do you recommend people get rid of their assets before
Ooh, good
death?
question.
As in, I mean, I know that has that can have Centrelink, things as well, but
Being duty.
Yeah.
Yeah.
is it a better idea?
Look, the lawyer answer is it depends on case by case basis, and that is the correct. But my personal view is yes, I think it's probably on balance. This is a stark generalisation. There's some real benefits in it. Yeah.
can a person that's been bankrupt be an executor of the estate?
Not while they are bankrupt. It's been bankrupt, but are no longer. Yes. Yeah, I don't think they can be while they are. Can't be a director.
Yeah. What happens if it's proven that the executive doesn't have capacity?
Sorry, question for the live streamers. If the executive doesn't have capacity,
I mean, that happens more and more with things like early dementia and stuff.
yeah,
The person may have sufficient capacity 12 months ago when you did the will, but over that period of time, you know, the conditions have changed.
certainly it is very foreseeable that, you know, if an elderly person appoints their partner as executor and then they pass away and then the partner has capacity at the time of passing, but before the estate's administered, that person loses capacity. You'd need to substitute them. Yeah, they can't be an executive without capacity.
Harrison, just one query following on the lady's question about disposing of your assets before you die. One of your lawyers has suggested that is a good idea. I just wanted to double check that if you have superannuation that has binding beneficiaries listed, that is beyond the challenge of a unhappy person.
Sheila Gray just entered the room. She's a really good person to answer this question. I mean, perfect timing. Sheila, correct me if I'm wrong, but so there are different ways you can nominate your super fund. Okay, so again, Sheila, correct me if I'm wrong, but if you put someone to get your super in your will, super fund's got to abide by that. No, not at all. Separate to the will. So the will is not, doesn't constitute that binding. They've got a separate piece of paper.
I wasn't doubting what Sheila told me. I just thought people in the room might like to know. Not at all.
But your question.
Don't worry, Sheila. I wasn't worried about your advice, but I thought the lady over there who asked the question might like to know that I think if there's a binding beneficiary, it can't be argued with.
Yes, and I was going to say that there are different types of nominations. It's a non-binding vote. But yes, separate binding. I think, Mark, though, your question is a little bit further than that in the sense that the super being taxed forms part of the estate.
Yes. Provided it is binding and accepted by the trustee.
Doesn't super form part of the estate, though, it can be.
Only if it's directed to the estate and it's made part of your LPR, or there is no binding nomination so that the trustee can direct it elsewhere. No. Yeah. I say all of us, we got together and wrote that together. No, so there's a couple of things. If there is a binding nomination, so let me start again. Sorry, Harrison, I've taken over your.
No. A lot of these questions are more yours than mine. You've got one. Yeah.
Yeah.
if there is a non-binding nomination, let me start again. Super funds can choose whether or not you can have a non-lapsing binding nomination, a lapsing binding nomination, a preferred nomination, or other things. So there are things like you can have a death benefit rule that builds stuff into your super fund deed, or a reversionary pension, or any of those sorts of things permitted by the SIS Act. So if it is a non-lapsing binding nomination, technically it's a set and forget. If it's a binding nomination, you need to be very careful whether or not it is a lapsing or non-lapsing, depending upon the terms of the super fund trust deed or the terms of the super fund managers, if it's a retail fund. If it's a reversionary pension, it will not lapse, but you do have to be careful about caps in super funds, because if you have a reversionary pension that drops the reversionary pensioner into a super fund that exceeds the cap, some will have to come out of super above that limit, which is currently MIF 1.8, 1.9. Yes. And if it is a binding death benefit rule, it is it's a similar to a nomination, but it actually changes the terms of your trust deed, and it is then built into the trust deed so that it is absolutely binding. However, if you have a super fund, say like Super Central, where every 3 years you have the option to update your trust deed, you need to be very, very careful that you don't update your trust deed and change the terms of it so that you've actually wiped out the binding death benefit rule that you put in place. Make sense?
Super. Long story short, super's a whole other kettle of fish.
Yes, get some extra advice about that.
Yeah. Revert to the first dot point in that last slide. Look, that's all I had run today. Thanks for those that have joined us on the live stream coming in today. Thanks for your input. Thanks for great discussion, questions. Hopefully you got something out of it. And yeah, look, there'll be some networking drinks and nibbles afterwards. Or just out here, it's not too cold. Maybe in the courtyard.